here with Lisa Peterson, Wisconsin Underwriting Counsel, and Wayne Wench, Wisconsin State Counsel, from the Fidelity National Title Group, which encompasses Chicago Title, Commonwealth Land Title, and Fidelity National Title. Today's title topic is judgments in general.
A search of the title is not complete unless a search is made for judgments, because upon entry in the circuit court where the land is located, a judgment constitutes a lien against all property of the debtor wherever located. In other words, the judgment doesn't have to have a legal description inserted. By virtue of having been entered by the court, it becomes a lien upon entry in the judgment and lien docket. So it's very important that a search of judgments be made for both the seller and, if it's a sale, the buyer of the property, for all files, for all commitments. The search has to be made for a time period. It has to be made for a period of time for 10 years. In other words, one has to go back and search for all judgments that were docketed at any time with the circuit court for the past 10 years. Now let's remember, what is a judgment? A judgment is a judgment that's entered by a circuit court in the amount of money damages. It's not a judgment for an injunction, a court injunction to stop you from trespassing on your neighbor's property. It's in an amount of money damages. It has to be a lien that was docketed in the clerk of circuit courts. There are many judgments that are not docketed. In other words, for reasons that are unknown, the prevailing party, the plaintiff, decided not to pay the $5 docketing fee and simply have the judgment filed in many cases, small claims court, which doesn't automatically get docketed in some counties. Remember, a judgment is not the same thing as a state tax lien. So when you examine the clerk of circuit court's records, make sure you know what kind of item you're showing in the commitment for title insurance. Is it a judgment or is it a state tax lien?
I see that a lot, Dwayne, where they just call it, we have some agents that just call everything a judgment, and they're different. A judgment is not the same as a state tax lien or a federal tax lien or any of the other plethora of liens that we have in Wisconsin. They are very different.
What kinds of interests in real property and real estate, if a judgment is docketed against that person, do judgments extend to? Well, if the debtor, if the owner of the property, who's the debtor, is the holder of fee simple title, then of course an entry of a judgment against her name is a lien against the real estate.
If it's docketed.
If it's docketed.
If it's docketed.
What about lessees? If the person has a recorded lease, yes, the name of the lessee should be searched for judgments as well. What if the individual against whom a judgment was docketed is the non-title spouse of the owner?
That's a good one. You don't have to show that one.
Don't have to show that. There's a specific law, a statute law, that says that it's not a lien. What if the individual is the holder of the right of first refusal or an option to purchase?
I'm going to go with no.
No, not in that case. So, very important to make a list of all these different interests in real estate, and in some cases the judgments attach, in some cases they don't attach. You don't have to search the shareholder of a corporation for judgments, because the corporation insulates the title to the real estate from liability for judgments against the individual officer, director, or shareholder.
What about a purchase money mortgage, Dwayne? What if I'm doing my title search and I've shown several docketed judgments that are against my buyer, and now I have a lender, the purchase money lender, who's really upset that I've shown all of these liens against his buyer? Now what do I do?
Good news. You can give this lender, your customer, some comfort by telling them that you're going to remove the judgment from the commitment for the loan policy, because by law, purchase money mortgages, even those that are recorded after the judgment against the borrower was docketed 2 years after, are first and paramount mortgages. They enjoy priority as against the judgment lien.
Now, is that for individuals, or would that apply if it was a corporate judgment and a corporate purchase money mortgage?
Both.
Both. Even better news.
Yeah.
So there's your good news for the day.
Right. But in some cases, the lender may insist that the judgment be satisfied. They may not be willing, even though they realize, and even though Lisa and I pound into them the idea that, look, good news, lender, your loan has first and paramount lien priority. We don't care. We want the title scrubbed clean. In fact, we even want you to remove something from the credit report. How's that? Can we do that?
Sorry, that's out of our world.
We can't do that.
We have a limited world in which we
can only remove stuff from commitments for title insurance, not credit reports. Judgments.
Should I talk about homestead?
Homestead.
All right, I'll tell you about homestead. So with judgments, one of the things that we are often asked when the judgment is against a seller, and the seller is selling their homestead property, and let's just say there's not enough money to go around. Maybe it's a short sale, or maybe it's just, I guess it would have to be a short sale, maybe a deed in lieu, but probably a short sale. So there's not enough money to pay everybody, and so everybody's scrambling at the 11th hour. What do we do? What do we do? How do we get rid of some of these different things? My caution to you as title people is you are not your seller's lawyer. You are the title person. So it's not for you to give all these options to the seller. That's the point at which you say to the seller, it might be a good idea for you to consult with counsel, because obviously you're up against a time clock here and you've got some judgments and liens that can't get paid. Let's say your seller actually takes your advice and goes to an attorney, and that attorney comes back to you as a title person and says, I've counseled my seller that they should take Wisconsin's homestead exemption. Is that okay? And the answer is yes, it is okay. Wisconsin does have a homestead exemption, and that homestead exemption says that if you are selling your homestead property, your homestead is insulated from docketed judgments up to a certain dollar amount. And it's not the dollar amount of the judgment, really, it's the dollar amount of your net, of your proceeds. So in other words, if you are a single seller and you are walking away from the closing with less than $75,000 in proceeds, you don't have to pay the docketed judgments. If you're a married couple, that exemption is $150,000. So in other words, you're walking away from the closing with less than $150,000 in proceeds, you don't have to pay your docketed judgments. Couple things to keep in mind. We already talked about the fact that it's really important to identify properly on your commitments the difference between judgments, state tax warrants, federal tax liens, child support liens, all of those other liens, because this exemption only applies to docketed judgments, not any of these other kinds of liens that are out there. Secondly, it's not your position as the closer or the title person doing the exam to counsel the seller that, hey, you have this exemption available, because that's like telling somebody what exemption to take on their income tax form. Not our job, outside the scope of our world. But it is available. If they choose to claim it, you'll need to have an affidavit filled out that you keep in your file. You don't need to record it. Those days are really gone. You just keep that affidavit in your file. Now, the caveat to that is if the judgments that you're looking at are large, and by large we're talking about any single judgment that is over $20,000 that they're claiming the exemption on, please contact us. We want to talk to you about that before you rely on the exemption. The exemption exists. However, over the course of the 20 years I've been doing this, that exemption has changed shape. There's been a lot of litigation on whether or not the exemption should even exist. So if you're looking at, for example, a $50,000 judgment where the seller is claiming the homestead exemption, we want to have a conversation with you about that before you just agree to accept that exemption, because we don't want to be the next case that says, gee, that exemption's not such a great idea after all.
What if the judgment creditor is the, let's put two hats on her. She's the ex-spouse of the debtor, and she's also an attorney.
Oh, I would say, good God,
A
call
collections
us.
attorney.
Yeah, call us. A collections attorney, even better. And they probably have a summer home in Illinois. For sure, call us on those. We look at the amount of the judgment, we look at who the creditor is, we look at the circumstances of the deal, because this exemption, unfortunately, hasn't really sat on very solid ground over the last 15, 20 years. It has changed shape through courses and case law. So we do want to take a look at those things before you agree to just take that judgment affidavit.
What if the title agency has reason to believe that the affidavit is not true?
Oh,
that
that's
it really
even
isn't
better.
their homestead?
Yeah, if it really isn't their homestead, again, call us. As with everything, I wish that Dwayne and I could sit here and give you all black and white rules for the world that we live in, but that's really not the case. So as with everything you guys are doing, if you have reason to believe that something someone's telling you isn't true, that's the point that you need to call us and talk to us about whether or not you should go ahead with what you're being asked to do. Because you'd rather have it as okay per DW or LP than going forward. So on that note, we would like to say thank you for tuning in today. You can find further information on the National Agency website, and as always, the opinions expressed herein are those of DW and LP and the Fidelity National Title Group. Thank you.
Thank you.